Legal precedent remembered. To recover a rightful expectation of restitution in the face of colossal deception, government collusion, and cultism, it is not unreasonable to consider or argue for criminal punishment for MLM rackets, as Edward A. Ross did in his time. There is historical legal precedent. Many people do not know or remember that the prosecution of the MLM Cascot, often cited for the court's landmark recognition of the inherent fraudulence of pyramid schemes, led to a prison sentence for the CEO, Glenn W. Turner. Few also know that the government also sought prison for Turner's attorney, F. Lee Bailey. Cascot was closed down, but Turner, in classic MLM fashion, opened another similar MLM that eventually led to his being sentenced to 7 years in prison in 1987. He served about 4 years. Partially retired and living in Florida, Turner died in 2020, age 85. The Cascot.com website redirects to Turner's namesake website, which still offers for sale Turner's videos, seminars, MLM speeches, and motivation courses. In 1998, the SEC charged the MLM International Heritage Incorporated with operating a pyramid scheme. This led the Department of Justice to bring criminal charges against International Heritage CEO Stanley Van Etten for fraud, obstruction of justice, subornation of perjury, and false statements. The SEC claimed, quote, investors purchased business centers, and IHI raised more than $150 million from over 155,000 investors. Van Etten was sentenced to 10 years, but was let out after 7 in 2012 for informing against his fellow inmates while in prison. Today, 2020, Van Etten runs a property management company in Charlotte, North Carolina. The IHI scheme was featured in a segment of CBS 60 Minutes in which the late Mike Wallace interviewed me to explain the nature of an unsustainable pyramid scheme. According to the News and Observer in Raleigh, North Carolina, where the scheme was based, the government determined that Van Etten's scheme was an illegal pyramid scheme because most of its revenue came from money spent by its recruits rather than from each recruit selling goods to the general public. They were selling hope, said Assistant U.S. Attorney J. Gaston B. Williams. In 2016, the U.S. Department of Justice prosecuted Paul Burks, the CEO of the MLM Zeke Rewards, for criminal fraud. In its direct selling disguise, Zeke claimed to offer a penny auction for its members to buy and sell various products. Participants purchased options for participating in the auction and could recruit others and gain rewards as they all participated. An investigation revealed the usual MLM pattern in which most funds used to pay rewards were actually coming from the new participants, not generated by the auction. As stated in the SEC charge, quote, without new investor funds from participants, revenue would dwindle substantially as less than 10% of daily revenues come from actual retail sales. I attended the criminal trial for Zeke CEO Paul Burks in Charlotte, North Carolina. The details of his MLM, typical of so many others, were laid out over the course of the 2-week proceedings. Zeke ignited the usual MLM mania. In only a year and a half, it exploded to $600 million in revenue with 1 million participants. A jury found Burks, 70, guilty in only a matter of hours. He was sentenced in March 2017 to 3 concurrent prison sentences of 14 years and 8 months. I asked Assistant U.S. Attorney Jenny Sugar why she had not called to the stand her retained pyramid expert, Dr. Peter Vandernat. She told me her DOJ team chose not to prove that Zeke is a pyramid or a Ponzi, only that Burks, quote, used deception to get money from people, resulting in harm, the essential elements of a criminal fraud. The other DOJ attorney, Corey Ellis, added that there is no federal law against Ponzi or pyramid schemes. However, he noted, the deception deliberately employed by perpetrators in such scams is illegal when it leads to harm, and federal criminal statutes do cover that wrongdoing. What the U.S. attorneys did not address is why the Justice Department was involved with Zeke, but not in all other prosecutions of multi-level marketing brought by the FTC. Those cases were relegated to the FTC, which cannot bring a criminal case, only a civil one. What made Zeke a criminal fraud and all the others not criminal? With Herbalife, the FTC took a nearly identical approach and dealt with similar facts as the DOJ did with Zeke. The FTC focused on the deceptive practices used by MLM pyramids and documented the subsequent harm, and it chose not to prove a pyramid scheme. But at the FTC, the same wrongs are not crimes, merely civil offenses. The MLM CEOs against whom criminal charges were brought, such as Turner with Coscott and Challenge, and Van Etten at International Heritage, and Paul Burks at Zeke, were in the mainstream of MLM. Turner's Coscott reportedly grew to $100 million in 1970 in revenue over a 3-year period, rivaling Amway in size and influence in the formative years of MLM. IHI was one of the hottest MLMs in the mid-90s. More than 140,000 people became sales representatives in just 1 year, and many more joined over the full span of the scheme. IHI CEO Van Etten later acquired and published Success Magazine, the MLM industry's flagship publication at that time. Zeke's scheme involved the best-known MLM lawyer in America, Kevin Grimes, not merely as legal counsel, but as a conductor of compliance tests for all Zeke participants. Before that, Grimes was in-house attorney for the MLM Melaleuca, whose CEO was finance co-chairperson for Mitt Romney's presidential candidacy. Grimes' other MLM clients included President Trump's now defunct Trump Network. In 2010, the Direct Selling Association awarded Grimes' law firm, Grimes and Reese, a partnership award, stating, quote, in FTC pyramid scheme actions, MLM defendants have sought out their firm for representation. At Burke's criminal trial, high-profile MLM stalwarts testified or were cited for their professional contributions to Zeke, for their industry activities on behalf of Zeke, of the type they provided to many other MLMs. Several were sued and fined. Among them were leads generator and trainer Peter Mingles and the ubiquitous MLM promoter Troy Dooley. The SEC stated that Zeke paid Dooley $6,000 a month for promotional services, including responding to negative press and promoting Zeke's founders, officers, products, and culture to bolster Zeke's MLM status. Dooley didn't disclose the payments to his audience. The SEC issued a cease and desist order to Dooley and ordered payment of a fine. MLM marketer Keith Lagos helped craft the Zeke story. He was later sued by the SEC for this work and fined $79,000. Gerald Nera, a famous MLM attorney who previously served as in-house counsel for Amway, was touted for his legal work for Zeke. Nera agreed to pay a settlement of $100,000. Kevin Grimes was sued by the court-appointed receiver and agreed to pay $1.175 million as restitution. In the Herbalife case, announced the same year, the FTC took 2 years for investigation. which followed 2 previous years of publicized research and revelations of consumer loss and Herbalife deception conducted by a major Wall Street company. The charges against Herbalife, quote, deceptive acts or practices likely to cause substantial injury to consumers that consumers cannot reasonably avoid themselves, were essentially the same as the Department of Justice brought against Zeke, and the 2 businesses were similarly based on endless chain recruiting, with false claims to direct selling. Though Herbalife's offenses were on a vastly larger scale over a far longer period, and Herbalife stock is traded on the New York Stock Exchange, the prosecution was carried out by the FTC, not the SEC or the Department of Justice. The FTC's civil case produced only a settlement that allowed Herbalife to admit no guilt, and no executives were charged at all. Not one of the consultants, promoters, PR firms, or attorneys who aided Herbalife in its deceptive practices was prosecuted. The pattern in these and other cases shows that when a Ponzi or pyramid scheme is classified as multi-level marketing, the government treats it differently. This is the legacy of the political fix established in the 1980s and upheld by both political parties. The MLM classification has become a de facto safe harbor from criminal law. In the rare instances where MLM promoters were treated as criminal perpetrators, such as Zeke Rewards, the schemes were recast more as securities fraud, cheating investors, though the operations were essentially no different from all other MLMs. Fraud is fraud, except when a company is classified as multi-level marketing. All companies classified as MLM are equal under the law, but some are more equal than others. Theft of the soul is